And now, Legal Perspective with Nick Clekis.
A major landlord with Charleston ties is in the spotlight. Greystar, the nation's largest apartment manager, has settled a federal antitrust lawsuit over claims it conspired to inflate rental prices. Joining us to explain the legal implications is Nick Clekis, owner of Clekis Law Firm. Nick, great to have you back with us. Welcome today. Can you remind us what this federal lawsuit was all about in the first place?
Yeah, so, it's about price fixing. It's about big corporations using their power to control whether it's rental units or it's Walmart or whoever it is to price fix because we don't have the ability to fight it. And so in the antitrust world or monopoly world, they don't want two companies doing it together to conspire or more, or one giant company, a monopoly, to do it. And so, as you know, what Greystar was doing was they were using that real page algorithm, a software that gathered information about prospective tenants, and apparently it was sensitive information. They didn't really spell out what that was, but I can only surmise that it was whether you're black and white or how much money you made or what you paid for your last rental unit. And they used that to kind of price fix what these units would be selling for, where to place them. Then the ones that were publicly advertised, there was misconceptions about what the prices really were. They were saying, like we were talking about earlier, you could get an apartment on Romney Street for $2,400, and then once you put your application, your non-refundable fees in, they say, oh, by the way, concierge fees and internet fees and trash fees and all this, and it turned out to be $2,800. The government said no. Yeah.
So when we hear they were using this software, the real page, was the Department of Justice, did they have a problem with them using the software just as it is, or was it because they were using it to price fix?
I think the problem with the software was that it was gathering the sensitive information, that they were using it in a way that kind of gave them an advantage. They control 1 million doors. They have 1 million units. And so, they started categorizing people and luring them to their properties based on information that they really shouldn't have. And it should really just be, hey, we have an apartment for rent. This is what it costs. And whoever applies, and it should be fair across the board.
And we keep hearing antitrust. Can you explain exactly what an antitrust lawsuit is?
Yeah, so it's kind of like what we just talked about. There's a Sherman Act, there's a Clayton Act, there's these acts that are out there to prevent these big corporations from taking advantage of us. Same as insider trading. You can't have Morgan Stanley calling, some other big trading company and saying, hey, we're going to do an IPO, and or the time that Martha Stewart went to jail because somebody told her, hey, they're getting ready to go public with this, go buy a bunch of stock. Those are the kind of things. It happens every day, but if they get caught, they're violations. You can go to jail for up to 10 years. Fines could be $100,000 to $1 million. It could be civil, it could be criminal, white-collar crime. So antitrust just means they don't want you to use information either collaboratively with another corporation or individually against, like if you're a monopoly, to just price fix and say we're just going to artificially raise prices because we can.
And now the settlement was reached earlier this month, and Greystar agreed it would enact a number of policies and adjustments, but they did not admit to any wrongdoing. How common is that in a settlement of this magnitude?
That's common in a lot of settlements. I mean, there are often times that we'll settle even smaller cases where the defendant will say that, they deny any negligence or wrongdoing, but they're going to pay us. What does that really mean? I mean, they felt like the software that they were using was legal and they could use it, but they're paying. The same way, if you're charged with a crime, you can go to court and you can plead guilty by way of what's called an Alford plea, A-L-F-O-R-D, Alford versus North Carolina. And what that basically says is that I think the government's got enough information to convict me, and so I'm not going to fight it, so I'll plead guilty under Alford, which means I'm not admitting to anything, but I'm still pleading guilty. Well, that's what they did. They basically said, okay, we're going to go ahead and give you millions of dollars, but we didn't do anything wrong. I mean, it's kind of silly.
I agree. So for Charleston renters here in Charleston, Do you think that we could see rent come down, or do you think the impact is more behind the scenes?
Now, you and I both know prices never come down.
Yeah.
Yeah, I think, hopefully what it'll do is it'll level the playing field somewhat so that, the whole goal of antitrust litigation and acts is to allow for free competition, to allow pricing to fall where it falls based on supply and demand, not on artificial conspiracies and backdoor dealings.
Well, hopefully this was a step in the right direction for apartment managers across the nation. Nick, thank you so much. All of your legal needs, 8439 Clekis.com is where you can go. Always a pleasure.
Always, thanks.
We're back in 2 minutes.
This has been Legal Perspective with Nick Clekis.